Okay, thank you. Thank you today and welcome to our next section, Introduction to Criminal Justice. This is section one, as you all know. It's a continuation of the course, Introduction to Criminal Justice. See the description. I think the core objective of the course is to make sure we can encourage. It's really intended for criminal justice students and practitioners of the system, as well as others who have interest in the profession. We stop sometimes back to the uh, era of, I think we talk about classification of crimes, we talk about misdemeanor components of the criminal justice system. We'd like to reach to that. But basically for today, we will continue with the subject, particularly the area that we stop. Let me just find something quick. Okay, we started, continued with, you did the definition of criminal justice. We analyzed it, and we continue with the analysis in terms of the definition. We went further with the definition of crime, touched on the elements of crime, talked about crime alliance, crime alliance, talk about search and seizure, the petition for the search and seizure. And so let's continue today with the rate of search and seizure. So we touched today the classification just a minute, just a minute. is taken. Let's start today with the continuing with the elements of a warrant, specifically the warrant of arrest, you have the requirements of a warrant, and then you have what we call arrest. So first we must have what are those conditions under which a person can be arrested under Liberian law, and specifically under also common law systems like the great United States that we practice. The reason we, in our practice of law, we make reference to the United States of America is that it's because of the practice of stare decisis, is the practice of customs, the practice borrow with age, the practice that you borrow from, because your law in practice must have some sources. So the sources of our practice in law, particularly in Liberia, are credited to the great United States and the British common law system. The reason is because America borrowed from Great Britain, the common law system, and then we borrow from America, and so they are similar kinds of way of practice. They share common traditions and doctrines in the application of principles of law. That is the reason we normally give reference to that. So you see, that's the common law practice system in fact. Now in America, as well as Liberia, you have three kind of conditions or requirements for an arrest. those requirements under our law are such that in order to have an arrest effected, there must be a warrant. If there is no warrant, an arrest can be questioned. Sometimes there is no warrant, but I think the last time I explained to you what a warrant is. The warrant is the order that comes from the court that orders a peaceful officer or a peace officer to arrest the living body of a particular person who will be called to answer to certain questions relating to violation of the law. In the context of this, the criminal law. If the warrant is not available, there is another way a peace officer can effectuate an arrest. He can arrest when there is a probable cause. You want to know what is probable cause? Probable cause has to do with those facts and circumstances that are known to a reasonable law enforcement practitioner that a crime has been committed and that the person to be arrested must have committed the offense. When you have those elements present, then you can effect an arrest. That's what we call probable cause. For example, if a victim goes to the police station and files a complaint at the charge of quarter, asking the police to intervene that a particular person had committed an offense against him and that they are victim of the crime, evident by the bleeding maybe, or the evidence of assault on the person, the police officer has the right to arrest that person who is accused of violating the penal law without a warrant. That police officer has jurisdiction and authority to do so. And that's what we call probable cause. Because the facts have been known to him that something had happened. And often, based on the way the evidence has been presented from the first stage, it's not a conclusion that the person is guilty, no. But from the first instant, that we call prima facie, from the surface of the case, they have reason to believe that they can proceed the way they want to proceed to arrest the person. So we call that probable cause. Another requirement of an arrest is the plain view doctrine. Under the plain view doctrine, it says that when the person who is a peace officer sees a particular person committing an offense or a crime, he has the right to arrest right there because the officer observes that the crime is committed in his presence. That's why we call it the plain view. So in criminal justice, in criminal investigation, in criminal law, we call that the plain view doctrine. You can arrest, you don't have to wait for a warrant. You can arrest when the crime or when the crimes are committed in your presence. Next thing I want us to look at is the requirement of a warrant. If a warrant, for the purpose of this code, is warrant of arrest, please indicate that. Have that mark is warrant, requirement of warrant of arrest. The first legal requirement of a warrant before the court issues a warrant of arrest, specifically the magisterial court, there must be an application, there must be a petition, or there must be an oral complaint to the magistrate or the justice of the peace that by the victim or by somebody that accusing a particular individual of the commission of a criminal offense. On that basis, the first requirement is set. When the application is written, the next thing is that the magistrate must ascertain whether there is a probable cause to establish, based on the complaint, to issue the writ of arrest. I just explained to you what is meant by probable cause. I said when any fact or facts are known to any reasonable law enforcement officer that a crime has been committed and that a person to be arrested committed the offense, that constitutes probable cause. The next requirement under the law for the issuance, in other words, for the magistrate or the justice of the peace to issue a criminal writ or a writ of arrest, is that the complaint must specifically state the crime committed. The court is not going to define for you or look for the charges for you or the allegation, which crime to know. That's why at the magisterial court, this is practical. When you go to file a complaint before the magistrate, which is a criminal complaint, the magistrate normally sends the person or you to the city solicitor or the prosecutor. You explain the facts and circumstances to the prosecutor. The city solicitor examines, analyzes, and examines your complaint. He will be able to identify the specific provisions under the law that the individual that is accused of committing an offense had violated. And so, when the magistrate sends that person to the city solicitor will indeed right away listen to the complaint, and then he writes the charges on the slip and send them to the clerk of the court. And he tells the clerk, issue a writ. These are the complaints, issue a writ for these particular violations. Because it is the state that files the complaint on behalf of a victim who is accused of a crime. When this is done, the next thing in question is that the warrant that is being issued, the court of law that is issuing that particular warrant of arrest, that criminal arrest, that criminal writ, that particular magisterial court must have jurisdiction. Jurisdiction is fundamental in any legal proceedings. It is cardinal. When a court of law issues an order, and that court of law does not have the authority, that we call jurisdiction, that authority by law to exercise the power that it is exercising, then it lacks jurisdiction. Then the court actions are ultra vires, meaning outside the ambit of the law. So, when the magistrate is issuing the writ of arrest, he has to make sure that that court, that magisterial court, has jurisdiction. And In the era of establishing jurisdiction, there are certain things that the magistrate must consider or the court must consider. One of the things that the court considers in terms of jurisdiction, meaning the authority to exercise that power, is to find out whether it has authority over the person in question to be arrested. Why do we say this? There are certain people in our country that our law, that our courts cannot just issue writs against them, because we do not have jurisdiction over some of them. And those people are people that enjoyed immunity expressed and given to them by our government. And who are those people? That people in the diplomatic cycle. If you check in our penal law, you look at the chapter 1, which talks about provisions. Those provisional areas of the chapter of the penal law. You will see area there that they talk about the doctrine of extraterritoriality. Then they talk about jurisdiction also, who can be arrested, who cannot be arrested. It is also in the criminal procedure law of Liberia. If a diplomat is accused of a crime, you can't arrest him right away. The reason is because before they came into our country, our government, under the International Convention of Diplomatic Immunities, Liberia has signed that particular convention. They signed that agreement, a convention. It says that officials of other countries and other states who are in your country, and I call it diplomatic immunities, cannot be subject to your criminal laws and procedure in terms of criminal violations. You cannot just arrest them. The government of Liberia has to first of all withdraw that particular immunity. That's why you see in our laws you hear about personal non grata, where the government can say the person they can only say the person is not needed in our country, we give 72 hours to live, 1 week to live. There are certain persons that cannot be subject to our criminal sanctions. Those are some of the category of persons. That's why the extension of that, that's why you see, for example, when these people are entering our country, or our country in particular, they are not subject to search and seizure. No, you can't do that to them. They are immune. That's what we call diplomatic immunity. Although in those immunities, they have certain things, they have qualified immunity and absolute immunity, but don't be bad about that. That's not your stage. That's your introduction to criminal justice. I'm just giving you the idea of jurisdiction. So, personal jurisdiction is that falls under jurisdiction. That's one of the jurisdictional issues. The next kind of jurisdiction that the court considers has to do with subject matter jurisdiction. The court that is issuing the writ must first of all have knowledge of the law to know whether or not it has the authority to issue a writ based on the allegation. If the allegation, for instance, does not fall under the jurisdiction of the court, or the court has no authority by law to issue that particular writ, the writ can be asked to be stricken by the defense counsel. For example, if the magisterial court goes to work to issue a writ on issues that are civil in nature, and then they criminalize those issues based on the facts in it that are outlined in the writ, because the writ has what we call aberrament. The writ can also state when you committed the crime, what kind of law you violated, and where it was committed, and the provision of the law that you have violated in substance. Now, if the defense counsel observes that the facts and circumstances in the case are actually issue of civil law, action of debt, or they are actions of what? Damages for wrong or damages for breach of contract. The lawyer can file a motion to dismiss the case on grounds that the rate is defective, that the court lacks jurisdiction on that issue. Or sometimes the magistrate can ask the magistrate to dismiss the case because the case is not a criminal case. If it was a civil matter, okay, but it's not a civil matter. The issue they bring, the criminalize a civil matter, dismiss it. In fact, the case now is in another court. Those are issues and other things. The next jurisdictional component that the court must consider in ordering the issuance of the writ of arrest is what we call the jurisdictional aspect that has to do with territory. Every magisterial court or justice of the peace court has its own authority. If the New Britain Magisterial Court, which is now the called Bruce Island Court, that is in Tuefan, issues a writ against a person for the crime that was committed in Central Monrovia, and then that magisterial court issued a writ, that particular writ can be questioned because the magisterial court lacks the territorial jurisdictional authority to issue the writ. So there are three kinds of jurisdiction that the court must consider before it issues the writ: personal jurisdiction, subject matter jurisdiction, and territorial jurisdiction. Let me say that again. There are three types of jurisdiction that the court considers in the issuance of the writ of arrest. The first is personal jurisdiction. The second is subject matter jurisdiction. The third is territorial jurisdiction. Let me give another example. If Monrovia City Court, which has jurisdiction from there all the way starting maybe to Oro, and then starts to from Oro, then it starts on Metlin Street, decides to issue a writ for the case that was committed, for the crime that was committed in Mabapoint or Johansi, the magisterial court lacks jurisdiction because the court that has the authority to issue writ of arrest for any criminal violation in Mabapoint, Johansi, and West Point is the West Point Magisterial Court. So I hope we grab those issues, the requirement for the word on jurisdiction. The next requirement of a writ of arrest is that the particular crime that is being alleged, it must be stated in the writ of arrest. The writ of arrest must state the particular crime that was committed. And that same writ of arrest must state the specific provision of the criminal law that that particular defendant had committed. Who is a defendant? The defendant is a person before a criminal court in the context of this particular, let's say criminal court. Because the defendant can also be in a civil court. But for the purpose of this criminal court, is the defendant. Yes, a criminal court. The particular defendant, the specific provision of the law that he violated, specifically in Liberia, if the man is accused for committing the crime of rape, which is a violation of section 14.70 of the new penal law of Liberia, the particular rape in question must state that particular section provision of the law under the penal law. If the rate does not state it, then the rate is defective. Another requirement is that the magistrate who is issuing the rate must determine that there is a probable cause. I listed that up, so no need for us to discuss that in the next section. Another thing under our law, which is procedurally required. When I say procedurally required, it means the criminal procedure law mandates that it must be done. No clerk of court on his own or her own can issue a writ of arrest without the authority of the judge. No way. There must be an order from the judge written in the case file specifically direct. That is, if the magistrate or the justice of the peace orders, Mr. Clerk issued a writ of arrest against the defendant in keeping with law and the evidence and the facts in the case, based on the petition of the prosecution, that magistrate goes ahead right away to issue the writ. If the magistrate issues the writ, that particular writ must state the court's jurisdiction. A writ will state the court's jurisdiction. And how does the court really state the court's jurisdiction? You will always see the caption of the case. In the writ, you will see Montserrat County, Republic of Labrador, Montserrat County. In the Montreal City Court, for example, the Montreal City Court for Montserrat County, for Montreal City Court, Montserrat County, Temple of Justice. Before his honor or before her honor, then they will put the name of the magistrate in his position, whether that's secondary or associate magistrate. Then it will state the court. In the Montreal City Court, it will be stated. So when you see the caption on the writ, the name of the court, it tells you that that court is expressing that it has jurisdiction to issue that particular writ. The next thing that qualifies the element of a writ of arrest is, like I told you first, it must state the law that is being violated. It must show that law. The next thing, it must describe or name the person to be arrested. The writ of arrest must always show the name of the person or describe the person. If they can't get the person for it, they will say John Brown or John, to be identified. To be identified means when the magistrate sees him and the private prosecutor or the private prosecutress, you ask who is the private prosecutor and the private prosecutress. The private prosecutor is a male who goes and complains that he's a victim of a crime. The private prosecutress is a female who goes to court and complains that she is a victim of a crime. So the person to be arrested will be described, or a name must be listed. The next thing is, the writ of arrest must state the date, the time, the place, and how the crime was committed. By at the person accused. It has to do that. If the rate does not do that, the defense lawyer, the man representing the person who is accused of the crime, can move the court, can ask the court, we call it application or the motion. He can file an application to the court requesting the court to strike the rate, that the rate is defective. The rate fails to state the date that the crime was committed. The rate fails to state the time that the crime was committed. The rate fails to state the place that the crime was committed. The rate fails to state who committed the offense. The rate also fails to show how the crime was committed. Because all of that should be contained in the affirmation of the rate of arrest. The next element that constitutes a valid writ of arrest for criminal case is that when the writ is issued, there must be a seal. There must be a seal placed on the writ. The court seal. The court has a seal that it stamps there. It places there to validate that the document is authentic. The purpose of the seal is for the authenticity of the writ of arrest. That is the purpose of the seal. To establish the authenticity of the writ of arrest, that it is valid. The next thing that is considered one of the elements of the writ of arrest is that the name of the magistrate or the justice of the peace or the judge ordering the issuance of the writ must be stated. Every writ must contain the name of the magistrate. So let's stop there today. We'll start dealing with these issues. We'll start dealing with law. We'll stop there today. The next time we meet, we'll talk on law. And then we'll go on to deal with classification of law. The classification continue. We'll go to the classification as it continue. Go to crime, classification of crime. Then we start with the criminal justice system, the components. Thank you for watching. As we have said always, please continue the transcribe to the something. Let me look at some of the questions, maybe before I leave. Somebody was asking, can the rate state take effect after the provision of the law isn't mentioned? When the person is asking if the provision of the law is not mentioned, but the court has authorized you got to accept the rate. Don't refuse a rate from court. Many educated people can do that. They refuse rate from court. Don't do that. That is contemptuous. 2, when you refuse a criminal rate, it's contemptuous. They can issue what we call order of arrest, so they can arrest you anytime. So normally you receive the rate, you come to court, and your lawyer will file a motion to move to dismiss the rate based on the defect if they fail to mention the specific provision of the law. Let me see any other question. If there's no question, thank you for coming. Please follow please try to subscribe. Please try to subscribe with the YouTube page. You can follow it because this thing is streamed simultaneously with my YouTube page. Continue on YouTube page because it is where I might likely in the future be dropping the document, the soft copy of the document that you can be able to access and use for future reading. Thank you for watching. Let's stop there today. Thursday we'll continue with criminal law. Thursday is criminal law, and Tuesday is introduction to criminal justice. When we complete the introduction to criminal justice, then we'll start with different codes. Maybe we'll start with criminology or corrections. Thank you. Good day.